Hello guys, welcome back to another video. So friends, today I am going to share with you about the writ of prohibition. What are its meaning, what are its nature and scope and object, and what are the grounds for filing it, and what are the objects of the writ of prohibition. So basically a writ of prohibition is a judicial order and it can be issued to a judicial or quasi-judicial authority when such authority exceeds its jurisdiction or tries to exercise jurisdiction not vested in it. The writ of prohibition is designed to prevent the excess of power by the public authorities. Formerly, this writ was issued only to judicial and quasi-judicial bodies. But the above requirement, this requirement is not longer valid now, and with the expanding dimensions of natural justice and requirement of fairness in administration functions, the rigidity about prohibition has been liberalized. This writ can be issued to anybody irrespective of the nature of the functions exercised by him, if any, on the grounds on which the writ of certiorari is issued is present. The writ of prohibition is now regarded as a general remedy for the court to control judicial, quasi-judicial and administrative decisions for affecting its right. The writ of prohibition can now lie against anybody irrespective of the nature of functions exercised by him. The writ can be issued to any constitutional, statutory or non-statutory body or a person exercising judicial, quasi-judicial and administrative actions affecting rights. A court martial constituted under the Army Act has been held to be subject to the writ of prohibition. Now, what are the grounds for issuing the writ of prohibition? It would not be out of place to mention here that the grounds of writ of certiorari and the writ of prohibition can both be issued on the following similar grounds. And now what are these grounds? These grounds are, first one is absence or excess of jurisdiction. In a case where there is absence of jurisdiction or total lack of jurisdiction, the writ of prohibition would lie against a judicial or a quasi-judicial authority, prohibiting it from exercising jurisdiction which is not vested in it. Thus, we can say that the prohibition was issued in a case of levy of license fee without authority of law. Similarly, if a taxing authority seeks to impose tax on a commodity exempted from the tax under the Act, a writ of prohibition may lie against the said authority. Second important ground is violation of principles of natural justice. A writ of prohibition will also be issued when there is a violation of principles of natural justice. As a matter of fact, if the principles of natural justice has not been followed, that is to say, if there is a bias or prejudice given to the person on the part of the judges, or no notice is issued or hearing given to the person against whom the action is proposed to be taken, then there is no jurisdiction vested in the judicial or quasi-judicial authority to proceed on this act. Next, third ground is unconstitutionality of statutes. A writ of prohibition will lie if a judicial or quasi-judicial authority proceeds to act under a law which is ultra vires or unconstitutional. Accordingly, we can say if the proceedings are pending in a court or tribunal under a statute which is ultra vires of any articles of the Constitution or is beyond the law making power of the legislation, then the writ of prohibition of lie against the said judicial or quasi-judicial authority. Next and important ground is infraction of fundamental rights. Writ of prohibition can also lie where fundamental rights are violated. Thus, in a case where an order was made transferring income tax assessment proceedings to another officers, prohibition was issued against the said proceedings because the order by which the proceedings were transferred was arbitrary and violative of Article 14, which provides for equality before law, was provided under Article 14 of the Constitution of India, was held as arbitrary. So friends, this is the writ of prohibition, and other writs has already been discussed, which has been provided in the playlist of administrative law. You may see in our playlist, and in case any comments or query, you may mention it in the chat box so that the answer thereto will be given for your queries. Thanks for watching this video.